Talk Show. Recorded live.
Well, welcome everybody. This is Matthew. I'm your moderator. Tonight is Wednesday, March 31st. This is our regularly scheduled Wednesday night conference call, The Free Americans. We have special guest Christian Walters to talk with us about new trust technology, NTT. We are continuing our discussion in the Gilbert Law Summaries on Trust. So without further ado, I'll turn it over to Christian. Go ahead, Christian.
Okay, thanks, Matt. Appreciate it. Like we might finish it up tonight, maybe the whole book. Take notice and acknowledgement and agreement that this show and our documents is private and not to be construed or relied upon as being legal advice for any individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure that is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic, informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the therein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Today we're going to start on Chapter 7, Accounting for Income and Principles, and it starts on page 235. I believe this is probably the last section in the book that we haven't really covered. So again, that's on page 235. It's Chapter 7, Accounting for Income and Principle. So the key exam issues here, in any question involving principal income accounting issues, the first thing you should do is analyze the expressed or implied trust terms, as these prevail over the general statutory or common law principles. Next, consider those general principles. Also be alert to possible applications of the trustee's duty or of impartiality in balancing and almost inherently completing the interest of income and remainder beneficiaries. Particular prominent areas to watch out for include, number one, the handling of income from transition periods, that is, income during estate administrations or income for periods within the testator or life beneficiary died, in terms of both what the trust is entitled to receive and how those receipts are allocated between income and principal, and two, extraordinary stock dividends or splits, and three, unproductive or overproductive, that is, wasting property problems. Also watch for distinctions between ordinary expenses and ordinary or capital expenditures, and for the possibilities of apportionment or depreciation/amortization treatment of the latter. Now Section A, Introduction. Number one, general nature of the principal income problem. A, successive interest, Section 847. In the typical trust situation, interests are generally divided between one or more income beneficiaries, usually for life or sometimes for other periods, and one or more remainder beneficiaries, whose eventual rights are in trust principle. Obviously, in most trusts, the economic rights of those two types of beneficiaries can conflict. Number one, classification of funds, Sections 848. The resolution of conflicting claims among beneficiaries often turns on the classification of funds in the hands of the trustee, either as income, which is the net income usually between payable currently to the life beneficiary, or as principal, generally to be retained in the trust estate for future interest holders. So thus it is essential to classify receipts and disbursements so that they will or may be credited or charged to or portioned between income and principal accounts. B. Discretionary benefits, sections 849. The importance of accounting issues and rules is affected by the nature of the successive rights of various beneficiaries, depending on whether trust accounting income may determine the rights of one or more of the beneficiaries. Number 1, discretionary power over distributions, sections 850. The seriousness of the problem is lessened but not eliminated where, as it often is the case, the life income beneficiary may receive principal and discretion of the trustee who holds for a power of invasion. The maximum rights of the beneficiary are not confined to income, but the minimum rights are set by the income account. The problem, however, is not present in the trust, that is, for so long as it is wholly discretionary, with or without a standard to guide the trustee's exercise of discretion over distributions, that is, a trust, quote, to pay L such amounts of income or principal or both as necessary for L's support, unquote, provided the discretionary benefit is limited to income. Number 2, annuity versus or unity trust interest, sections 851. Nor does the distinction between income and principal matter for strict, that is, without an income ceiling or floor, annuity trust interest, specified even indexed, dollar amount to be paid periodically, or unity trust interest, which is paying a specific percentage of principal, usually valued annually. Number 2, sources and priority of accounting rules, section A, trust terms, section 852. Like most questions of trust administration, unless there is a controlling public policy restricting the settler's freedom, terms of the trust govern trust principal income accounting questions whenever the matter is covered expressly or by an intention that can be found by construction of the trust provisions, that is, implied. B, legally implied rules. Number 1, state law, section 853. If a particular accounting issue was not covered by the terms of the trust, it will be resolved in accordance with the applicable state law, usually by the terms of the state's principal and income statute, which all states at long last have in one form or another. Many still have a version of the revised Uniform Principal and Income Act, 1962 Act, and a rapidly growing number have adopted a newly revised Uniform Principal and Income Act, 1979 Act. Gaps in statutes may be filled, perhaps under statutory mandate, by common law principles or resort to generally accepted accounting principles, or GAAP. Next page, 237, number 2, accounting rules, section 854. The specified rules of trust accounting often differ from general accounting principles because the trust law is influenced by special factors. Students trained in accounting will sometimes be quite surprised at trust law's strange lack of respect for non-financial concepts of net income. For example, there is a tendency for some types of issues to favor income beneficiaries, reflecting the settler's probable intent, such beneficiaries usually being closest to the settler. There would be a tendency in other situations to avoid a forced income distribution of properties or funds likely to be important to maintaining the properly functioning trust estate. Examples of income bias include apportionment of certain routine expenses between the income and principal, and a lesser inclination that in other accounting fields to charge depreciation against income. An example of less frequently occurring principal bias is the unusual retention of stock dividends entirely as principal without acknowledging underlying differences in the practices of various corporations. These matters are discussed below. A, note. These preferences or biases are not so much applied by courts on a case-by-case basis as they are built into the design of specific rules for application generally to the particular type of recurring issue. C. Trustee discretion, 855. By the terms of the trust, the trustee may be given private rulemaking authority in principal income matters. What the settlor intended as a matter of interpretation in the trust provision. A settlor, of course, should attempt to be clear about the scope and nature of this discretion. The power may be interpreted, 1, to allow the trustee to override other trust provisions or legally implied rules if in trustee's judgment it appears appropriate to do so. Example, in the trustee's judgment the provision or rules appear unfairly or unduly harsh as applied to a particular trust and situation, especially in light of the trustee's chosen investment program, or 2, to be used only where the instrument or the law does not provide clearly or at all for a particular matter. Number 1, broad construction of trustee's authority, Section 856. Many courts have construed the trustee's authority broadly under such powers. See Germain versus Germain, Massachusetts, 1938. Even on this issue, courts not only differ, but a given court may waver from time to time based on tedious distinctions. Number 2, note, within the scope of discretionary power, the trustee's decision is usually controlling as long as it is made reasonably and in good faith. Impartiality, D, Section 857. In general, as other aspects of trust administration, the law is designed and trustees' accounting judgments are expected to reflect an overall fiduciary duty of fairness and impartiality to all beneficiaries, while at the same time respecting expressed or implied purposes, preferences, and intentions of a particular settlor. Number 1, adjustment power, 858. The trustee's duty to make trust property reasonably productive of income while observing the duty of impartiality may inhibit the trustee's effort to invest normally on the total return basis. Thus, the 1997 Act, prompted by the modern prudent investor rule, allows a trustee to compensate a beneficiary whose interest suffers, usually the income beneficiary, when the trustee undertakes an investment program that has a greater total return expectation, emphasizing, example, stocks heavily over bonds, intended for a long-term benefit of all, but that does not fulfill the usually dictates of the duty impartiality. To satisfy those requirements, the trustee may exercise an adjustment power. 1997 Act, Section 104, increasingly statutes are adding an unitrust option, see Supra, Section 851, as a proxy for the income right if the trustee so elects, and compare the restatement to the 3rd, Section 79, comment I, use of common law power / duty of equitable adjustment. Now the exam tip. If you encounter an exam question that involves principal income accounting issues, remember that the first thing you should do is analyze the expressed and implied terms of the trust, which prevail over the general statutory or common law principles. Next, we should read that again. If you encounter an exam question that involves principal income accounting issues, remember the first thing you do is analyze the express or implied terms of the trust, which prevail over the general statutory or common law principles. Next, you should determine whether it is a statute that governs the particular issue. Keep in mind that a court, if broadly construes a trustee's discretionary power over the accounting matters. Finally, remember that under the 1997 Act, if a trustee determines that by following the trust terms or statutory rules, she is unable to comply with her duty to administer the trust impartially, the trustee may make adjustments between principal and income to extent necessary. Section B, specific rules of trust principal income accounting. Number 1, allocation rules or default rules, Section 859. Where the trust instrument is silent, the trustee is not expressly given accounting discretion. The rules of allocating benefits and burdens between income and remainder beneficiary are as follows. Number 2, allocation of benefits, essentially receipts, Section 860. The trust income is payable to the income beneficiary while trust capital belongs to the remainder beneficiaries and is invested for any future income beneficiaries. Trust income includes all ordinary receipts from use or investment of trust property, and in this category falls rents, dividends, interest, etc. Extraordinary receipts are generally trust capital unless they are in some manner to be apportioned. This includes proceeds from sale or exchange of assets, settlement, or most claims for injury to trust property, etc. A. When right to income commences, Section 861. The income beneficiary is entitled to the net income from the date of creation of the inter vivos trust or from the date of death in the case of a testamentary trust, even though there is an intervening period of administration of settler's estate. See the restatement second, Section 234. B. Earnings of testamentary trust during estate administration, Section 862. As indicated, the earnings on a trust corpus during administration of the decedent's estate are generally allocated to the income account for the testator's settler's date of death, even though not payable, of course, until the trustee receives distribution of the trust funds. Number 1, distinguished non-trust gifts, Section 863. If no trust is involved, the amount of payment and date from which it is computed would depend on whether the gift was a general or a specific one. The usual rule is that the legatee of the specific bequest, example, my 1,000 shares of U.S. Steel, is entitled to actual earnings on the funds or property bequeathed from the date of the death, whereas the legatee of a general, the dollar amount or pecuniary bequest, example, $10,000, is entitled only to the statutory rate of interest, not necessarily the actual earnings, on funds involved commencing 1 year after the date of death. See the will summary. Number 2, rule where trust involved. A, the general rule, Section 864. In trust accounting, the general rule is that the income beneficiary is entitled to all earnings on the trust estate from the date of death. What these earnings are, however, may follow the will rule above, or perhaps more often, any interest payable to the trust may commence at the date of the testator's death. Example, if testator devises purple acre to brother in trust, income to child is entitled to purple acre account net earnings from the time of testator's death, the standard result with or without the statute. B, statutory view, Section 865. In 1962 and 1997 Acts provide that the income beneficiary or pecuniary amount bequeathed in trust is entitled to the net earnings after deducting net income, specific devices, and bequests on the portion of the estate equal to the pecuniary amount from the date of the death. See the 1962 Act, Section B2, and see the 1997 Act, Section 201, Section 3, and Subparent 4. Example, if testator bequeaths $100,000 outright to brother, brother has no right to the actual earnings on the compounding $100,000 portion of the estate during the period of administration. Brother's only right to the statutory rate of interest on that sum commencing 1 year after the date of death. On the other hand, if the testator bequeaths the $100,000 to brother in trust to pay the income to child for life, remainder to the grandchild, child is entitled to the actual net earnings after deductions on the portion of the estate equal to $100,000 from the date of testator's death. Number 1, rationale. The apparent rationale is that where the testator makes a gift of income of certain property of funds in trust, it is indicative of her intent that the gift would be effective to provide for the life beneficiary from the date of her death. Number 2, note, not all statutes follow the above rule. Some statutes of some cases provide for statutory interest from the date of death follow the non-trust pecuniary or bequeathed rule, also for trust, where it is interest from 1 year after the date of the death. Number 3, residuary trust, earnings of other estate properties, Section 866. Note that there is a conflict of authorities where there are earnings during probate that are derived from assets which do not ultimately become part of the trust estate. Example, testator creates a trust of the residue of her estate and the various assets are sold and used during probate to pay off pecuniary bequests, taxes, administration expenses, and claims against the estate. The income from the assets clearly become part of the trust estate. It falls to the residue. Should the trustee regard such receipts as trust income or as capital? A, the majority view, income, Section 867. The majority view is that the receipts are income. This is the so-called Massachusetts rule and is adopted in Section 5 of the 1962 Act and continued in the 1997 Act. B, the minority view, principle, Section 868. There is some authority contra that limits the income beneficiary to income attributable to the assets that come into the trust. And under this view, the earnings from any sources, that is, earnings here in question, are entirely allocable to the trust corpus. And see Baldwin versus United States, that's in 1962 case. Section C, minority view, apportionment, Section 869. Still other cases apportion the earnings between the income and principal accounts based on a formula that applied to apportions receipts from the sale of unproductive property. See Infra Section 892. However, this rule, although often said to be sounder answer, is less popular than the other rules because of its supposed complexity. Now the graph there, earnings of testamentary trust during estate administration. Under the type of bequeathed in trust, the example is where T bequeaths Blue Acre in trust for L for life, remainder to R. And who is entitled to the income earning during the administration? Under the specific, L is entitled to net earnings on Blue Acre, example of RETS, from the date of T's death. Now the type of bequeathed in trust, the general or the pecuniary. The example is T bequeaths $50,000 in trust for L for life and the remainder to R, and who is entitled to income earned during the administration. And the general, L is entitled to net earnings minus net income of specific devices and bequeaths on a portion of T's estate equal to $50,000 from the date of T's death. Now the type of bequeathed in trust, the residuary. The example is T bequeaths all the rest residue and the remainder my estate in trust for L for life, remainder to R, and who is entitled to income earned during the administration. Under the residuary, the majority view is L is entitled to all earnings that fall into the residual, even on assets that do not eventually become part of the residual, and from date of T's death. Now the minority view, L is entitled only to earnings from the date of T's death on assets that come into the trust, earnings from date of T's death on assets that were sold to pay debts, expenses, and pecuniary bequeaths are principal. And the minority view, earnings from date of T's death or portion between income and principal. Next, page 242. C, timing of receipts, apportionment of income as between successive beneficiaries, Section 870. A frequent issue between successive beneficiaries is whether income received at the death of the testator or life beneficiary should be allocable to the basis of when it was received or on the basis of when it accrued. Example, on the death of life beneficiary B, income becomes payable to another income beneficiary. C, do income items received by the trust after B's death but accrued during her life belong to B's estate or to C? Number 1, the common law rule, no apportionment, Section 871. At common law, the income is usually allocable to whomever was the income beneficiary at the time the trustee received the income, regardless of when the right to such income accrued. Example, if annual rents were paid to trustee on January 1, covering the use of trust property during the preceding year, and C had become the income beneficiary on December 31st, C would be entitled to such rents. B's estate would get nothing. See Fraser versus First National Bank, Alabama, 1938. Section A, exception, apportionment of interest income, Section 872. Unlike other types of income trust, is deemed earned on a day-to-day basis and hence is allocable ratably to whomever held the right to the interest income as it accrued. This is an exception to the general common law rule against apportionment. Dexter versus Phillips, 1876 case. Number 2, general statutory review, apportionment, Section 873. Under most statutes, all income except dividends is apportionable in these situations. Number 3, minority statutory review, Section 874. Under some statutes, income generally is not apportioned. However, some distinctions are drawn in several of these statutes between testamentary and inter vivos trust. Section 8, payable before death, Section 875. Monies received by testamentary trust are regarded as principal if they are payable before the decedent's death. B, certain installment or periodic payments, Section 876. Even though not payable until after death, certain installment payments, example, promissory note payments, received by a testamentary trust that cover a period both before and after the settler's death are apportioned. That is, the portion of the payment that accrued before the date of death is principal and the balance is income. This approach may apply to certain other periodic payments under some statutes. C, other situations, Section 877. Otherwise, receipts to a trust, testamentary or inter vivos, are treated entirely as income, that is, no apportionment, even though earned, accrued, or otherwise payable before trust was created. Example, interest accruing on a bank deposit is income of the trust exists when the deposit is credited, even though it was earned in part before the deposit was transferred into the trust. D, special rules governing dividends, Section 878. Difficult problems arise in connection with the dividends received by a trust from corporate stock, that is, determining whether a particular corporation's distribution is trust income or trust principal. Number 1, ordinary cash dividends, Section 879. Ordinary cash dividends are easy, they are income. Number 2, extraordinary dividends, cash or stock, Section 880. There are several important issues about whether the extraordinary dividends are income or principal. A cash dividend is extraordinary either because of its size or circumstances. All stock dividends are extraordinary. A, Massachusetts rule, modern statutory view, Section 881. Whether an extraordinary dividend is income or principal depends primarily on whether its distribution or its payment to the income beneficiary would impair the trust's proportionate interest in the declaring corporation. And that's Minot versus Payne, Massachusetts, 1918. And see the restatement of the second, Section 236. Number 1, stock dividends, Section 882. Thus, in what is by far the most frequent application of this principle, dividends payable in stock of the declaring corporation, whether technically or divided or a split, are always allocable to principal. Number 2, extraordinary dividends in cash or other property, Section 883. Extraordinary cash dividends or distributions of other property, including stock of another corporation, are usually by statute allocable to principal, even though in these statutes the trust would normally retain in some percentage of ownership in the declaring corporation. Allocation to principal is appropriate because such distributions are usually received by trustees by reason of total or partial liquidations as defined in the statutes with some variations in detail, or by trustees' election under an opinion to receive either cash or shares of the declaring corporation. In some exceptional distributions of these types, the cash dividend may be income. See Restatement of the Second, Section 236. Number 3, Special Rule for Mutual Funds, Section 884. Cash or other property received by a trust is allocable to principal if paid to the trustee by reason of capital gains or liquidation distributions received by mutual funds or other regulated investment companies in which the trust owns shares. Cash distributions may be mutual fund representing an ordinary dividends or interest or income to the trust. B, Pennsylvania Rule, One-Time Minority View, Section 885. A probably extinct minority view was that extraordinary dividends, whether paid in stock or cash, were principal to the extent that they reduced the book value of the shares below what it was when the stock was acquired by the trust, otherwise they were income. That is, the trustee had to determine what portion of extraordinary dividends represented surplus, that is earnings, accumulated since the trust acquired those shares, with only that portion being allocable to the income beneficiary. The rationale was that the remainder beneficiary was entitled to have the intact value of the shares retained. Number 3, Other Corporate Distributions, Sections 886. The same common law and statutory rules, see Supra Section 883, allocate corporate distributions of stock rights and options and proceeds of the sale to principal. Exam tip. An easy way to remember whether distributions received by a corporation are allocable to the income or principal under the modern view is that money received from a corporation, example cash dividends, is characterized by income unless the distribution was quite large or received in partial or total liquidation of a corporation, and all property other than money received from a corporation, example stock dividends, is characterized as principal. E, Allocation of proceeds from sale of trust assets, Section 1, Sales in General, Section 887. All proceeds from sale of most trust assets, but see Infra Section 890 through 895, are principal that has become part of the trust capital account. A, Effect, Section 888. Under ordinary circumstances, only the principal account is credited with profits and charged with losses realized on the sale. B, Income Elements, Section 889. Gains on sale of investments and other capital assets go to trust corpus even when they represent increases in value that eventually would have been realized and distributed to the income beneficiary as rents, royalties, dividends, etc., had the trustee retained the investment. Number 2, Underproductive Property, Allocation of Proceeds of Delay Sale, Section 890. Except for a special provision on marital deductions trust, see IRC Section 2056, the rule on unproductive or underproductive property below is expressly abandoned in the 1997 Act as being inappropriate when income productivity is based on trust portfolio as a whole and in light of the trustee's adjustment power under Section 104 of the Act. Over time, judicial decisions and amendments to other statutes can be expected to follow. A, Background. Trustee's duty to sell. Section 891. A trustee is often under a duty to sell property that becomes unproductive or underproductive. See Restatement of the Second, Section 241. Under the 1962 Act, property that annually yields less than 1% of its original appraised value or market cost is classified as unproductive. See 1962 Act, Section 12. B, Apportionment Rule, Section 892. If a trustee finds it necessary to hold such property as its sale is delayed, she is to apportion the net proceeds of the sale between income and principal in such a way as, in effect, to give the income beneficiary an amount representing and reasonably likely to approximate what he would have received had the property been sold as soon as the duty to sell arose. Usually under the 1962 Act, the first year of the property earned less than 1% of the value, and had the proceeds then been invested in normal productivity property. Note, number 1, the rule applies whether the sale produces more or less than the cost or appraised value of the property. Number 2, interest, section 893. In calculating the income that would have been earned on normally productive property, the common law looks to the going rate of the return on the trust investment in the community. Under the 1962 Act, however, the rate is stipulated at 5%. The 1962 Act, see section 12B. Number 3, bond or note in default, section 894. Where the property involved is a bond or a note that is in default, a dubious version of the common law rule might give the income beneficiary the interest rate agreed upon in the bond or note if that is higher than the average trust investment would have earned. See Restatement the Second, section 241. See illustration, apportionment computation, section 895. The trustee was unable to sell until 5 years after the investment became unproductive and then received $250,000 net for it. Assuming an average 5% average trust yield totaling 25% for the period, that would be 5% times 5 years without compounding, the principal is ascertained by the dividing $250,000 by 1.25 for the proceeds represents 100% principal plus its supposed earnings of 25%. The result, allocate $200,000 to principal and the rest, $50,000, to income. F, treatment of wasting assets, section 896. A wasting asset is any property that is depletable or perishable through use, example, timber, minerals, patents, annuities, copyrights, etc. Number 1, bequeaths or divides of properties generally, section 897. Where a wasting asset becomes part of the trust estate during general terms in the settler's will, example, all my estate, or the residue of my estate, it has been typically been presumed that the settler intended both the income beneficiary and remainder beneficiary to enjoy the benefit of the property. Hence, the trustee must either provide for amortization, deduct from income and set up a reserve, or sell the property and invest in permanent securities. Number 2, specific testamentary or inter vivos gift, section 898. On the other hand, where the settler makes a specific gift during life or by will of a wasting asset to the trust, example, my oil well to T in trust for B for life, remainder to C, the income beneficiary has typically been allowed to receive all receipts on the rationale that this is what the settler must have intended in making a gift of the income from an asset that is depletable. Number 3, open mines doctrine, section 899. Where mines have been opened prior to creation of the trust, all the receipts therefrom are treated as income payable to the life beneficiary. A, distinguished mines opened after creation of trust, section 900. If, however, the mines are opened by the trustee after the trust is created, the receipts have been treated as principal, which the trustee must invest, the investment income being payable to the life beneficiary. B, criticism. According to the critics, this distinction gives the life beneficiary either too much or too little, and the principle of amortization applied in other wasting asset cases above should apply equally to mining operations. Exam tip. Remember that receipts generated by mines that were opened prior to the trust creation are treated as income, while receipts generated by mines that were opened after the trust creation are treated as principal, which must be invested by the trustee, and the receipts generated by such investments belong to the income beneficiary. Number 4, Uniform Act, section 901. Under the 1962 Act, payments that represent merely the rental of a wasting asset are allocable to the income beneficiary, whereas production payments and the like are subject to apportionment. The 1997 Act provides for apportionment, generally 10% income, 90% principal, of deferred compensation, liquidating asset distributions, and oil and gas receipts, and a more complicated set of rules for timber. See the 1997 Act, Section 421 through 424. These rules have been viewed by some as unsatisfactory, especially for retirement benefits, and are being amended to a growing number of states. G. Bond premium and discount, Section 902. Bonds often sell at a premium or a discount as a means of adjusting the bond's contractual rate of interest to the market rate at the time of sale. If the bond's rate is higher than the market rate, it will be sold at a premium. If it is lower than the market rate, the bond will be sold at a discount. Some bonds bear no interest, but in lieu thereof sell only at larger discount, reflecting a full amount of interest to be earned upon redemption. Number 1, non-interest-bearing bonds, Section 903. In the case of non-interest-bearing bonds, the increment on sale of redemption traditionally has belonged to the income. That same result may be achieved by anticipating the eventual profit on redemption or sale by making appropriate periodic payments from cash flowing into the principal account. See the 1962 Act, Section 7A and C, Restatement of the Second, Section 233, Comment D, but see the 1997 Act, Section 412B, where payment received on zero coupon bonds and the like is generally principal, relying on the adjustment powers, see Supra, Section 858, to cope with any resulting overall unfairness to the income beneficiary. 2. Other cases, interest-bearing bonds. A. Premium, Section 904. The restatement rule has allowed but has not required amortization of premium by retention of excess interest in the principal account to repay the account for the loss on redemption, unless not to amortize would be unfair in light of the trust investments as a whole. See the Restatement of the Second, Section 239, Comment F. B. Discount, Section 905. The rule provides that discount cannot be amortized to increase the income payment out of anticipated profit to principal on redemption prior to the sale or redemption of the bond, but then the proceeds may or may not be apportioned as fairness dictates. See Restatement of the Second, Section 239, Comment B. C. Uniform Act, Section 906. Legislation in some other states precludes amortization of either premium on or discount on bonds except in non-interest-bearing bonds. See Supra, Section 903, 1962 Act, Section 7A. This rule effectively casts the responsibility for impartiality upon the trustee's balanced investment decisions, easier said than done. Number 3, allocation of burdens, essentially expenditures, Section 907. The general rule is that the trustee should pay the extraordinary current expenses of trust administration out of trust income, whereas expenses that are extraordinary or solely beneficial to the remainder beneficiaries should be paid from the capital account. Generally, the cost of keeping the trust property productive and secure is borne by the income account. Likewise, the income account is chargeable with all expenses of trust operation that go into the production or collection of income, while the principal account is chargeable with expenses that go to the improvement or preservation of the trust corpus. But see Infra, Section 918. A. Losses from operation of business, Section 908. Any loss sustained by the operation of a business owned by the trust has been held to fall in the principal. That is, such losses are carried forward into the other year in determining profits or income. But see Supra, Section 858. B. Taxes, assessments, Section 909. Ordinarily, property taxes are charged to the income account. Number 1, assessments for permanent improvements, Section 910. However, assessments for capital or permanent improvements are generally handled as follows. Usually the entire assessment is charged to the principal account. Under appropriate circumstances, the income account thereafter may be charged with depreciation or amortization of the account involved. The 1997 Act allocates expenditures related to environmental problems to principal. See 1997 Act, Section 502A, subparent 7. Number 2, permanent, Section 911. Of course, the big problem lies in determining whether a relatively long-term improvement is permanent improvement. It has been often treated essentially as a question of fact or judgment, but generally, if the benefit is one that is likely to last until the remainder beneficiary comes into possession, is considered permanent. With amortization, the handling need not be so arbitrary. See upkeep, Section 912. Current repairs, maintenance expenses, and assessments for temporary improvements are chargeable entirely to the income account. See the restatement of the second, Section 233, comment E, and the 1962 Act, Section 13A, and the 1997 Act, Section 501, subparent 3 and 4. Number 1, insurance, Section 913. In many states, premiums for insuring trust property are also chargeable to income, but other states call for apportionment because principal is protected as well as income, probably reflecting income bias. See SUPRA Section 854. Number 2, initial costs, Section 914. However, when a trust is intentionally established, the cost of putting trust property into rentable or income-producing condition is chargeable against principal, even though the expenditures is of a type that would subsequently be a repair and maintenance item chargeable against income. See restatement of the second, Section 233, comment I. Number 3, distinguish capital involvements, Section 915. Long-term substantial improvements are treated and defined, see SUPRA Section 910, differently in different states. Some apportion between income and principal based on life beneficiaries' life expectancy or other supposedly appropriate basis. Other charge the expenditures initially to the principal account and then depreciate, see Infra Section 921, and others simply charge to principal. D, mortgage payments, Section 916. Interest on mortgage debt secured by trust property is charged against income, whereas the principal element of each mortgage payment is charged to principal. See Ellis versus King, Illinois, 1949. E, trustees and attorney's fees and other administrative expenses. Number 1, income charged by some, Section 917. Some of the earlier cases charged the trustee's compensation and related administration expenses entirely to the income account, at least in the absence of special justification for contrary treatment. Premiums on trustees' bonds are still generally held chargeable entirely to the income account. There was a case there aside that. And Section 2, now generally today's apportionment, Section 918. Such administrative expenses, however, include the fees that are payable to the trustee and to attorneys for their services, and usually also cost of accounting and judicial proceedings, are now generally apportioned equitably between the income beneficiary and remainder beneficiary. See restatement of the second, Section 233, comment H. A, discretionary appointment, Section 919. In many jurisdictions, the amount of each interest must bear is within the reasonable discretion of the trustee, subject to review by the court, and varies with the circumstances of each case, example, nature of services rendered, whether services benefited one interest rather than others, values of representative interest, etc. B, presumptively equal apportionment, Section 920. In many states, however, often by statute, such expenses are split equally between the income and capital accounts in the absence of showing of special circumstances. F, reserves for depreciation, Section 921. Considerable litigation has centered on whether the trustee may pay the income beneficiary their earnings from the depreciable income-producing property, example, commercial real estate, without setting up reserves for depreciation to protect the interest of remainder beneficiaries. Number 1, special provisions, Section 922. Of course, any explicit instructions by the settlor will be given effect. Number 2, instrument silent, Section 923. Where the trust instrument is silent, there is a split of case authority and considerable diversity among statutes. A, the traditional view, Section 924. Some cases have held that the trustee may not deduct for depreciation unless the trust investment expressly requires it. That is, that the burden of deterioration and shrinkage in value falls entirely on the remainder beneficiaries. Page 251, allocating assets and expenses, a summary. The receipts under income is ordinary cash dividends, and under principal, it's stock dividends and splits. The receipts under the income of ordinary receipts from use or investment of trust assets, example, rents and interest. Under the principal, extraordinary receipts, example, proceeds from sale of trust assets. And under the income under the receipts, the rental payments, perhaps reduced by depreciation, portion of production payments from wasting assets, perhaps subject to depletion. And under the principal, the portion of production payments from wasting assets. Now the income receipts, the increment profit on sale or redemption of non-interest-bearing bonds, and under the principal, the receipts, remaining proceeds from sale or redemption of non-interest-bearing bonds. And now the expenditures and losses, the income under expenditures and losses, the ordinary property taxes, and depreciation or amortizations for long-term improvements. And under the principal, the expenditures and losses is the assessments for long-term improvements. And the income for current repairs, maintenance, and expenses and assessments for short-term improvements, insurance premiums, under the expenditures and losses. And now under the principal, the initial cost of making trust property rentable or income-producing long-term improvements, perhaps with depreciation charged to income. Now the income, the interest on mortgage debt, under the expenditures and losses, and under the principal payments on mortgage debt. And the last is the income on expenditures and losses, be the portion of trustees and attorneys' fees and administrative expenses. And under the principal, it is the portion of trustees and attorneys' fees and administrative expenses. 252, number 1, note. Some of these states only require depreciation to be charged with respective properties purchased by the trustee, but not on depreciable assets originally transferred to the trustee by the settlor. B, another view, Section 925. In some states, by decision or statute, the matter is left to the sound discretion of the trustee whether to set up depreciation reserves and deduct for depreciation against income account. C, possible and majority view, Section 926. The majority view today may be that depreciation reserves are mandatory under at least some circumstances. It is presumed in either or all, or in some circumstances, depending on the state, that the settlor intended to preserve the corpus intact for the remainder beneficiaries. Thus, if the trustee holds depreciable assets and pays out current income without deducting for depreciation when required, she is personally liable to the remainder beneficiaries. The 1962 Act, Section 13A, subparent 2, requiring depreciation to be taken on all property, but that which is used by the beneficiary as a residence, but see Section 1997 Act, Section 503B, that leaves the matter to the trustee's discretion, as in B above. And that ends Chapter 7. And we'll open it up for questions now.
All right. I did see one caller that has been patiently waiting from South California. Go ahead and unmute him here. See if I can get my screen to...
Does it ever rain in Southern California?
Still trying to get him to unmute here. Come on, computer. Let me try it this way. I'm not on my regular computer tonight, so it doesn't seem to be wanting to respond here. While I'm waiting for that, I'm going to jump on my other computer as long as I got it up.
Hello?
Yep, no, there you are. You finally got on.
Thank you. Thank you for taking my question. I was just wondering, maybe it's not relating to this conversation now, but maybe it is. But I was wondering if you've been announcing for a while if we wanted to get access to the workshops and the whatever the classes were going on, to send an email, and I feel like I did, and me and my friends, and we didn't get a response, and we know what the next step could be to have access to the workshops and the classes.
Yeah, if you did send me a response, I have it on file, and I just might not have responded back. When I send out the registration application form, you will get one. So
that means resending an email?
Yes, we're sending out an email, or somehow you'll get it, yeah.
Okay. Is there a new address or something, or is it the same address we should send it? Or because we really would like to get access to it.
I already gave an address so that you wouldn't be sending it anywhere, so it'd probably be emailing it back and forth.
Okay, because we just didn't get any response. And
well, the website went down. A lot of the emails were locked up in there. I couldn't respond back to them just yet, so.
Okay. Just retry again, and hopefully we'll get a response back, and then that's how we can get in?
Well, I'm saying that don't expect a response. If you sent me an email, I've got it. I've got you on the list.
Oh, okay. And then what is the next step after that to get access to the trainings or the workshops or whatever?
Well, we were going to kind of been holding back on that because for different reasons. But anyway, when the workshop does get announced, you will get an application and a.
Okay. Just be patient and.
Yeah,
trust.
just hang in there. We got growing pains.
Oh, okay. Okay, and and are you still working on getting to the access to how to change our IMF?
Yes, we're working on that right now. Yeah.
Status, to change our status, because I was just approached this week with I had a CID interview with two CID agents because I had a small return last year filing 1099 OID, and they never contacted me for that. And this year they just knocked at my door, and they wanted to meet with me, and I just met with them Monday, and it was quite an experience. They said they want the money back and so on and so forth. So.
Well, did they give a reason why you're supposed to give the money back?
They mentioned about the it's nerve-wracking. They said we're done with these people, and they said that you have to be aware that there is a public federal national debt, and this money is supposed to go in order to pay this, and you stole this money. What you did is illegal. It's a crime, so on and so forth, and you're not going to get another refund this year. Forget about it. And we're going to take this to the next level, and they're threatening me and all that stuff. So I kept asking them questions, but I did depose myself a few times. So who are you, and where were you born? What's your birthday? Identification. I didn't give them ID, but it's nerve-wracking for an hour and a half, like that. So.
Yeah. But
Any input?
Ask them why did they say that you owed it back?
Basically, they say it's a crime, it's illegal. I stole it. They mentioned about the public federal debt and that I'm not allowed to have this and so on and so forth. And they said you will give it back. You will have to give it back. And so anyway, and I said, well, okay, I conditionally accept your offer upon proof of claim that there's something wrong in my, in my filing. Point it to me. I want to see if there's a problem. I'm here to solve it, so on and so forth. And they just would not. They did not get any papers out on the table. They would not point at, so they could not prove it. In other words.
Sounds like a lot of smoke and mirrors to me.
Yeah, and that's what they're about. They're really good at what they do, and so they're trying to catch me in many different angles, but without proving anything and without laying anything on the table. So.
Well, sounds like you did pretty good.
Huh?
Sounds like you did pretty good.
You think I did pretty good?
You have to keep bringing them back to the point.
I said here. I'm here to solve. I'm here to bring a solution. Would that be okay with you to show me, to point, the specifics? If obviously there's a problem, you're here. You wanted to talk to me. What is it? Show it to me. I'm here to zero out the account. I'm here to bring a solution, to help, to solve this matter. And they just would not point anything to me. It was like, so, and they had a thick, like 1 inch thick or maybe 2 inches thick of their folders. I knew they had their paperwork about me with them, and yet they didn't show me anything. So, yeah, it was quite an experience.
Well, thanks for sharing that.
You're welcome. Any input on that, based on your knowledge, and why is it that they're telling me they want the money back right now? What is that about?
Well, they can always make an accusation, but then, that's just an NOI. They should substantiate it with an SOI. Where's the material fact to substantiate their claim?
Yeah, that's what I was requesting them. Upon proof of claim, I fully accept your offer. Upon proof of claim that you show me, what's wrong. Prove it to me that it's a crime. Prove it to me it's illegal. As far as I know, that I not use the IRS forms, it's like, so.
Right.
So it was interesting. But, yeah, they didn't like me, actually. They said, well, you're not cooperating. You're not answering our questions. This is going anywhere. We're wasting our time. We're going in circles. Well, I said, how would it look like to not waste our time here? Well, you would answer our questions. Well, am I not answering your questions? The way I want to answer your questions. It was interesting. So.
Yeah, it just sounds like they want you to roll over and die, and then,
totally.
Here's a check for it.
Well, of course, in their eyes, I was not cooperating, but in my eyes, I think I was doing great. So, my intention was not to, to depose myself in their hands. It was just like that. So, Anyway, it was quite a test. It was quite an experience. I don't wish this to anybody.
I can understand that. Yeah. Well, have another question? Anything else?
No, that's it. I was just curious if you had a specific input on that, and why is it that they're doing that, and why is it they were questioning me, and why is it they say I have to give the money back, and what could be the solution, the remedy for this, and if there is one.
Well, I would come at this under the NTT and treat it as a special deposit. Their offer and that special deposit merge the two titles, and that merging would be the payment.
Yeah, I'm just wanting to respond right now within the next 72 hours with a letter, a notice, constructive notice of conditional acceptance. I fully accept all the facts in the meeting upon proof of claim that, based on my position in the private. So, in their eyes, in the public, of course, I'm not allowed to the returns to these funds, but in the private, I am. So.
Right.
I'm just trying to explain to them my position, and so I was wondering, based on the trust, if there was any other angle you would approach it.
Did they send you any other kind of paperwork or anything?
No, not since the meeting. It was just a hearsay, like just a verbal kind of contract. they said that they said, you know, you may not see us again, but some of the people will contact you, and we're going to take this to the next level. And there was just, I said, are you threatening me right now? You know, and he said, well, we're not. But I said, what are you doing then? So, yeah, they're pretty intense. They're good at what they do.
Right.
But I was trying to stay calm. I was trying to stay in honor and polite and kind. So.
Okay. Well.
Yeah, so that's it. I was wondering if, you know, with the trust angle, if I could approach it differently.
Yeah, it would be different because totally different, coming from a different direction.
Yeah, I was told by some friends that, you know, expressing the trust, and I did mention to them, I said, you know, am I not the grantor here, you know, the grantor settler in this matter, and who by Aline's signatures, you know, that who created these interests, these withholdings, and well, you know, based on the trust, well, they said, what trust? You know, tell us about grantor. What's that? You know, and well, what about why is there, you know, a BC, a social security card? You know, this what's up with all these securities? Well, they're not securities. You know, it's like tell us about trust. What trust? So I try to approach it with that angle as well. And as soon as I mentioned the trust, they got off their chairs. They started to get off the chairs. So that was interesting.
Hitting home more, I think. Yes.
Huh?
Hitting home more, I think.
Yeah, it just I could feel that that's when they left. You know, it's like even though they wanted me to talk about it, but they were leaving at the same time.
Oh.
So it was interesting. Anyway, I just thought I would mention if you have any insights or whatever, and I would have been curious to hear.
Other than the simplistic answer that I gave, you know, the more details than a lot of the other downloads in the past that we've gone over, talked to pretty much in depth of how to merge the titles and using the moving titles and platform according to NTT.
Mm-hmm.
So I don't know if you've gone through the past downloads and audio recordings.
No, not all of them yet. No, I didn't have a chance to listen to everything.
Pretty much we got quite since last October, since really October last year, but we really started getting on NTT since November. So anything November and forward, especially till present.
Okay. My friend was just saying the core problem, the core issue here is my IMF. I'm you know, in their eyes, I'm the trustee in the IMF file.
Yes, right.
So yeah, and if it was changed, this would not be an issue. It would not come up to the grantor, you know. So.
Yes, correct. And then we're going to merge the titles. We'll pay all past debts, present debts, and all future.
So this is coming pretty soon. We'll have access to be able to do that.
Yes.
Awesome. Well, thank you so much.
Oh, you're welcome.
Okay.
Thanks for calling in.
Thank you.
Muchu, you did you want to jump in here?
No, I think she just did a really great job. That's all.
Well, you're up next if you want to ask Christian your question.
No, it's okay.
Okay, you had asked me to unmute you, so.
Yeah, I'll mute it. I'll mute it. Well, she covered everything.
Okay. Got a couple more here. 3-1. You've been unmuted. Go ahead.
Okay. I was just wondering, I got in a little late here, but I was trying to correlate the information that we were reading tonight with what we're doing, and how does this really affect us and what we're trying to do. I mean, if we were going to be maybe doing trust in the public, this might be something that would be, apply to us. But I can't really see a connection here and what we're doing in the private with this.
Well, this whole Gilbert is really the black trust. That's the statutory trust world. It is all public, and it really doesn't really tie into anything in the private. But it's the
I'm just trying to relate it. That's what I'm doing.
The administration, there's all kinds of. I'm trying to get everybody to start to see not how to form another trust, because there are plenty of trusts out there. We're flush with trust everywhere. I'm trying to get everybody to see on the public side these big fat pig trusts that are out there already fresh for the butchering. They're full of cash, they're full of assets, and you've created them, and we don't have to do any conversion. I'm trying to point out the fact that we've got a lot of assets out there that we just haven't been living off them. We're kind of like in India. We've got these sacred cows all over the place, but yet we're starving.
Well, how would we apply this to when we move the title of the trust and replace it with the LLC? How would this come into play then? That's what I'm trying to figure out.
Well, we still have to know how to administer the trust and not commingle.
Yeah.
And
okay.
That's the thing, because we still have to operate until we get things changed. The public realm still exists, and we have to learn how to operate in it.
Yeah.
We have to learn how to administer that public side trust or that LLC. And it's all pointing out here. It's all according to GAAP, really. They run all these statutory trusts according to GAAP.
Okay.
GAAP and private agreements. I mean, it might be too much to say it's all soak in all at once, because we're covering a large expanse, and we're covering a lot of territory that should have been studied over many, many years, and we're trying to cram it all down at once.
I feel like I'm cramming for an insurance exam.
Yes, I know. But, I think that was the last section, unless we want to review something. But what we'll probably get into next is we're going to get into the Lewin book, the Practical Treatise on the Law and Trust.
Yeah.
That's what we'll do next.
Yeah, I wanted to read those first 12 pages that you recommended that we do that, and I haven't had a chance to get to it yet. Anyway,
actually, the 19 pages is really the first section. That's just the introduction, the first 19 pages.
Yeah.
It breaks down the first 6 pages is really the old trust, the uses, fee off the uses, and then the next 6 pages, up to page 12, takes you into the modern trust. And then the last 6 pages, completes the whole section out.
So you've got, the first 20, 24, 30 pages or something like that? Does it cover
19. First 19.
First 19. Oh, okay. So if we really learn the first 19 pages, then we pretty have it down pretty cold. Is that what you're saying?
Once you get through the language in there and get it figured out what the language is, because really it's the language barrier or the code key is really in understanding the definition of the words. Because the word usage is the key to unlocking it. Word usage, because certain words are in a particular law form. And we choose our law form by the verbiage that we're specifying when we speak it or we read it. Words are used in a key way. The words are switches that will turn the wrong thing on if we use the wrong verbiage, if we use the wrong words. Because there are certain words that they use that they have specific law form invocations. You actually invoke the law form that you want by the words that you're using.
Like set a key.
Yeah. There's all these portal words that could portal into, say, debtor-creditor under UCC, or it could portal into trust under equity. And And you can actually choose your law form just by the verbiage that you're using without even coming out and saying, I want to choose, say, common law, or I want to choose equity, or I want to choose statutory. You just put the verbiage in there, and you are determining by the words that you're using the law form.
Well, that
So
brings
words,
up...
Words are key.
Yeah. Chattel means the same in law or in trust as it does in debit credit, doesn't it?
Yeah, there are some words that could be portal words that could go either way, and then there are some words that are exclusively used, and there's no question about what law form they're in. Yeah.
Okay. Yeah, I know that these. I was in checking through this. Some of the terms like the officer or whatever it was, I can't remember. Anyway, that I think meant beneficiary thing, or maybe it meant trustee. I couldn't remember.
Let's see, it's the fee is trustee.
Yeah, okay. That's
Petty fee is beneficiary.
Yeah, right. Okay. Yeah, fee. That's the one that I was having a problem with. That's trustee. Okay.
That's trustee. Yeah.
Okay. Well, I'm just going to have to study it. That's all I'm going to have to do.
Yeah, the first 19 pages. Yeah, that's a foundational thing, really.
Yeah, I printed it out so I could carry it around with me because every time it seems like when you have to sit at your computer, you don't get as much done.
It's the first 19 pages is the key to understanding the whole book. Okay. In fact, it's key to understanding what they're doing now.
Okay.
Back to it. I can't get out of the first 19 pages.
Okay. All right. Well, I'll study it some more. Okay. Thanks, Christian. How do I mute myself out?
I'll get you.
Oh, okay.
Backfire. In the process of getting you unmuted. Ask Christian your question. Same thing again. It's just not responding very quickly. Apologize for the delay, folks. Try it again.
I got 3 more pages that I have to print out. I got I got 16. I got the first 16 pages. When I sit at the computer, I can't get this thing read.
You're on the air, Floyd.
Yeah, we're still trying to get you muted out here.
Oh, I was just talking to my wife.
We all know.
Yeah, okay. Now you know my secrets.
You got your strategy.
Right. No, he said he has. You said you have to mute me out, didn't you?
Yeah. Try to hit star 8 on your phone. See if that'll mute you out.
Star what?
I'm just about flipped over to my other computer here. You saw my desk. I have about 6 computers all up, all doing different things. And
that's your problem. You got too many computers.
Yeah. All right.
Probably operating off the wrong one. You're pushing the wrong buttons.
Exactly. Okay, here we go.
They're confused.
I just got free one muted out. Now, Tackfire, you are unmuted. Oh. Sorry about the delay there. Go ahead with your question.
Hello.
Yep,
Hello.
go ahead.
Yes, who's this?
Hello.
Who's this?
Like broken record.
Hello.
What's your question? I didn't hear you.
You talking to someone else?
All right, I'm gonna mute out Backfire and get our next guest on.
Yeah, can't quite catch him.
Yeah. Our next caller is guest number 4. If you can hear us, go ahead and state your name, where you're calling from, please.
Would that be me?
Go ahead.
Okay, thank you. This is Albert from Texas.
Hey, welcome to the call.
Thank you, Christian, and thank you for taking the time.
Hey, Albert. How you doing?
Okay. I've got a question. It's a horse of a different color. I don't think anyone's asked about this, but I've got a girlfriend who has a girlfriend. Now, she was injured at work, and she went through the process of, reporting it. It was ignored, and she got the documentation she needed from the doctors and went to the boss, gave it to him, and they told her to go home until further notice. So she did, without compensation of any sort. And since they wouldn't send her to their doctors, she went ahead and took care of her injury. Now, after 9 months of no communication, she filed an equal employment discrimination complaint. She didn't think she had a choice. The union just ignored everything that she did, and so did her boss. So while she was there, she filed the proper papers. That the only information that was available to her was to follow the process. And they've been toying with her for the last 6 months. It's just been ridiculous when I read all her documents. So what I'm asking is, how can I use this process to help this lady to make her claim? Is there anything you see? What's your opinion on this?
Well, there's probably a way you could turn it into a trust and get them in breach of trust and go after them under equitable breach of trust.
All right. There's several players. So I guess the main culprit in this would be the boss.
Yeah, let's see. You say there's a union involved? A union?
There was a union involved, but they disinvolved themselves, so to speak. In other words, they just turned their back.
With the employer, she was hurt on the job, right?
Right.
So you'd have to establish that there was a trust relationship between her and her employer, and then with the elements and the methods of formation of trust, be able to prove that there was a trust, and then come up with some kind of breach of trust then.
All right, with the union contract be the contract where they breached?
Possibly. I'm trying to think. It might be just better just to treat the employer-employee relationship as a trust and somehow come up with some kind of a deposit for the formation of the trust and get them in a breach that way.
This is a little different, and I just wondered if this new trust technology had any play in such a scenario. So I know that
she filled out an application form for employment because there's where the original signatures went down, and that's where the trust was formed then.
Oh, great. That is a real good one.
And then from there, then I would say that from a special deposit you would have made as being the application, then it was being held, generating, say, interest, and since there was no disbursement to the income beneficiary for the disbursement or payments, then she could claim breach as beneficiary and come at them for breach of trust because there were no receipts back to her of any kind of payments.
All right, thank you, Christian. And if you come up with anything else, it pops into your head, I'm listening.
You would use the doctor's injuries and things pertaining to that as being maybe a trust res deposit. Give them those documents as trust res.
Very good.
When they don't do anything from that, then that would be the breach. Because
I knew you had an answer.
From the interest generated off the special deposit would be the amount of money she needs to be compensated for her injuries.
And is that a question, as to the amount?
Anything that she wants. The interest can be any amount that's necessary to cover the bills and the damages that have been incurred.
Okay. I don't think this lady wants to learn all that's needed to go to court with this, so I don't think she could do it anyway. So this is probably her.
Example for everybody else. How NTT could be applied to any kind of situation, no matter whether she goes ahead with it or not. That would be solely up to her discretion, and her amount of knowledge. Whether or not, like you said, could she walk into court and prove and prove it and claim trust, and then come at them for a breach of trust. But anyway, that's how I would handle it.
Thank you, Christian, very much. I certainly will, convey this information to her, and hopefully she's got the trust res document. Usually, most people that sign into an employment situation, they usually don't keep that first document, or they do, they lose it in the attic or something.
Yeah, well, you could probably subpoena that document if you had to.
Okay. But do you foresee that a situation like this would probably take them into the private side of the court?
Yes, she would have to go into chambers and probably prove the trust.
Oh, man, this is going to be a whammy. Thank you, Kristen.
Okay, thanks.
Looks like Tagfire jumped back on here. We'll see if we can bring him back on. Tagfire, can you hear us? You've been unmuted.
Oh, thanks, Kristen. How are you today?
Better. We can hear you now.
Oh, okay, good. Hey, Kristen, having some real good success with the 2891. About ready to close out a situation down here. We want to go ahead on and send you copies of the documents. Got a whole bunch of them filed. But I wanted to go back to the individual out in California that had the folks showed up. They have been doing that for quite some time. When you sit down with them and you have a tape recorder going, they won't ask any questions. They'll leave your house. They don't want anything on record. They're not going to leave you a card showing what's the ID office they're out of, Fresno or Atlanta or wherever they're operating at. You're correct. It's all smoke and mirrors. I have not returned not one dime of my money. It's been a year now, and they better keep on going. So, the stuff that we're learning here from you guys today is very helpful. And I hope we be able to keep it up. I'm going to stay wired as much as I can. Been in Canada for 3 weeks, so it's kind of hard for me to get on, but I'm back in the USA. Thanks a lot for all your support.
Okay, thank you.
We ready for the next one, Christian?
Yeah.
Tedman, you've been unmuted. Go ahead with your question.
That was actually a good thing that he said there about, hey, putting down a recorder on there, recording a conversation, and then they get scared and they walk off.
I've also heard if you're a notary, you can depose them and swear them in and tell them you're an officer of the state. And they get real excited about that, too.
I've also heard if you're a notary.
In fact, you stay longer.
What was that, Tedman?
Yeah, caller, go ahead.
Tedman, can you hear us? He was there a second ago.
Hello?
Go ahead.
Hi, is it Christian?
Yes, go ahead.
It's Paul from Byron Bay, Australia again. I've got the same question for you. We've got that one regarding the birth certificate. We've got a court case happening, and 2 of the children were born in the bush, no birth certificates, and the court are trying to take the kids off her. And I've spoken to Peter. He basically handballed the question to you, and that's why I'm calling you again on it. What do you recommend? Could she claim? She wouldn't be claiming the kids, but if they kind of want her to sign a birth certificate so they become wards, so they can then dish the kids out and take them away from her. So I'm wondering, could she claim if she does sign the birth certificate as grantor, she could then become the co-trustee with the government, and obviously the kids are the beneficiaries.
I might want to do a special deposit and have the kids and it's going to benefit her also. That way I could make it as grantor beneficiary. Make them the trustee, get them in the breach then.
So you'd go and do the UCC 1 and 3, and then become a beneficiary as well, not the trustee.
Yeah, actually, the birth certificate is not the child. It's just a piece of paper that's fiction. Turn that birth certificate over and do an endorsement on the back there. Put out without recourse, and pay to, and then put in blank. Don't leave that blank. And then put your signature in there as grantor/settler. Sign your name, and below that put the straw man entity that you're signing for, all caps, security number, say. Now you've turned that into a payment instrument. It's actually a security, and whoever the bearer is, that was payment.
Yeah, I'm not quite understanding.
The obligation, whatever they're claiming.
I don't quite understand what you're saying there.
Yeah, that should release the surety from any suretyship, release the surety from the undertaking that they're trying to get them in.
Well, the kids are only 2 or 3 years of age. The children are only very young.
Do they have any work that they've presented to them?
Well, she's in a hearing that the father's trying to take the kids off her. And she's sort of hasn't got a lawyer or anything, which is probably a good thing. But being the mother, I thought she'd be in the superior position to claim because they want her to give them a birth certificate. They want her to
really
sign.
there's a case going on right now, right? There's an open case?
It's an open case right now. She's got to go back to court in a few days.
Okay, there's where we're going. See, you didn't tell me all the facts. Okay, now there's where I'd come in and form the trust off the case. That's what's hitting her there.
Say that again?
The case itself, turn that into a trust.
Yep, I understand that. Yep. She didn't. Can she do that if she wasn't the grantor on the case? Like she wasn't the one who called the case. It's the father who's calling the case. So wouldn't he be the grantor on the case, though?
No, the documents that she got from him, the original complaint, turn that into a special trust res and turn it back into a special deposit.
Okay.
Turn the whole case into a trust.
Oh, okay. All right. I understand that part of it. Yep. Now, what about the birth certificate? Even if she does have to put these kids in, because it's not a bad thing to be part of a straw man. I think the kids will need to be in that. She could then sign that then as a grantor.
All you have to do is talk case documentation, that what she got from the original complaint and all the other pleadings and motions that the plaintiff was throwing at her. Take all that, incorporate that as in one trust, and return it all to them as a special deposit as payment for merging the two titles. The offer that they gave her, which was the original complaint, which was the title to the debt, and then what you gave back to them was the title to the asset. So now that piece of paper is functionally both as debt title and asset title. When you return it to them, then do the merging of the two titles, and that's going to terminate the trust.
Okay. Yeah, I understand that. That's the part. Yeah, that's what she's dealing with right now. What about the fact that she has to get a birth certificate anyway? Would she sign those birth certificates rather than being the informant on the birth certificates? She'd be better to sign those over as the grantor, wouldn't she? So and put an indenture in, so when the birth certificate's made up in the titles office, so she gets a certificate of her title, but she'd be forming the indenture and how she wants that birth certificate to run. You know what I'm saying? Because
say that any
if
way
you had
you wanted, knowing how the parties, since you're the grantor, you can spell it out any way you want to.
Yeah. Okay. Yeah. Well, she's got that opportunity because the kids are not registered. They haven't got a birth certificate. So I thought two of them haven't got a birth certificate. One has.
Right. She has the opportunity to set it the way she wants it now. So if she wants to set it up so that they're the beneficiaries.
Yeah. And could she be co-trustee with the government? Because the government basically come in as trustee anyway, don't they?
Yeah, they're supposed to be trustees, but they're misconstruing us to be trustees. And then they dedupe us into creating the records and self-assessing us as trustees.
Uh-huh. Oh, so she'd be better off not being the trustee then. But who would be the trustee?
How your understanding is, you can play both parties if you know which way, and actually it's a win-win situation, but you have to understand both parties.
What, you can pay beneficiary and trustee?
Well, as trustee, I could say, well, I didn't make a payment. I agree with you. I agree that I owe you something, but then I can't pay it, and I'll tell you why I can't pay it if we go into chambers.
Uh-huh. But then you'd have to tell them that there's no such thing as money, and that they don't believe in that crap. They don't believe that.
I would say that the reason why is that this is a discretionary trust, and I can't give payment to the beneficiary, you guys, because you guys are bankrupt, and so it's per my discretion, and that's why I can't breach the trust myself. So,
tell me, that's interesting. You brought up an interesting point. How would you ever convince a court that the court is bankrupt? What evidence would you bring to court? Because I want to see evidence of that.
I really don't have to prove that. All I have to do, I have to prove that there's a trust. And upon trust, now I can't be the one that's forced into breaching the trust. It's just like there was something I read tonight. I forget to ask where it was. I don't remember. But it was talking about, maybe I did mark it in there. Let's see.
So what you're saying, the onus is on them to prove they're not bankrupt?
Yes, because under trust, the onus of probandi, the burden of proof shifts. And now that's the whole secret. That's the power of the trust.
I get it now. Okay. I get that. Yeah, I understand. That's when you go from the, substantive phase to the...
Correct. Yep.
You've mentioned that before. What is it again? You go from the...
The trustee is presumed and can't prove himself innocent unless he's got a record of a payment.
Yeah. Okay. So they're in bankruptcy, so that's up to them to prove. Isn't it up to the trustee to make the proof?
Well, see, I'm not going to prove about bankruptcy. I'm going to prove that there is a trust, and now but I'm going to prove that it's a discretionary trust. That takes precedence over all law forms, really. That's what I'm trying to dig up here where I was reading.
Christian, what documents are you bringing into the in-camera hearing to prove the trust?
The UC3 county recording.
Yeah, so it's your witnesses?
Yes, the records for proving that there was a trust.
So you're not bringing the actual documents themselves meaning the original res or anything. All you're bringing in is the notices that you filed in the public record that you got certified copies of.
Yes, the notices get attached to the public side, and then the actual SOI evidence, that's where it comes in chamber.
Well, so you do actually bring in the actual SOI
yes,
evidence.
The trust, you're going to bring in the...
That would be required under discovery anyway. So
this was on page 238 under section 858. It was in the exam tip below that. It says,
238.
If you encounter an exam question that involves principal, income, and accounting issues, remember that the first thing you should do is analyze the expressed and implied terms of the trust. So we're talking about the indenture, or what was the will or the intent and purpose of the grantor. And continue on. It says, which prevail over the general statutory or common law principles. I read it twice.
Yeah, I got that.
Sure. Or the intent and purpose of the grantor prevails over statutory and common law.
Wow.
So I can prove that I got a trust that was a discretionary trust, and it was the intent and purpose of the grantor that I can't breach the trust because it's per trustee's discretion to make a payment. And if I assume that even an assumption that the creditors are going to take the beneficiary's asset as soon as I make a payment, I can't breach the trust myself. And that's the legal right that I have over statutory and common law not to make a payment.
Not to make a payment.
Not to make a payment. Yes, because it's discretionary, per discretion of the trustee. But then, by the way, I will make a payment, make the beneficiary solvent so the creditors won't jump on his asset. How much do you need? Here's a payment. I could do that also.
But in this case, it's children. No payment.
Whatever. It's all the same thing. It's all a piece of paper, a birth certificate, talking about a value. But it's not a value. It's a res. It's a thing.
Oh, okay. So the payment. Okay. Yeah, good. Yeah, I understand. So the payment means give the kids to me.
Now, that's the trustee end. Now, let's take the beneficiary end. If I just make a prima facie case that they're the trustee now, and I'm the beneficiary, make a prima facie case as a claim against them, the court of equity is going to assume the trustee's guilty.
Yeah, that's what I would thought.
So either way, I could play it.
Yeah. I think the court would understand the second way better than the first way.
Yeah.
Yeah, the beneficiary way. Make them the trustee, so that really puts them, like you say, in a rock and a hard place. Yeah.
Because now our problem here is that we set ourselves up by self-assessment that we are the trustee by the individual master file in the IRS by filling out the 1040 forms and the other stuff that we put in there. So now we got a conflict. So if we say we're beneficiaries, better have some information set up that we're not, and we better be acting at that way. Otherwise, we'll have to go back in and correct that individual master file. So it comports to what I say I'm beneficiary. That master file also says I'm beneficiary.
Would that be in this case, though? But this is just pulling a leaf off a tree, isn't it?
Well, I don't know how it is there, but I'm saying specifically for us over here.
Well, it would be the same here. We've got the same. We've got the Australian Taxation Office, which is a subsidy, or what do you call subsidiary of the IRS.
Right.
In fact, they use IRS case law in ATO cases in Australia, so they must be the same. But we would be a trustee. But would that matter in a court in this particular instance? Because, as you say, we've got the Citi Trust, which is we're the beneficiary. But in the tax office, we are a trustee. So I don't understand why you need to have that file cleared up. That means what you're basically saying is we couldn't go to court at all on any matters unless we get the trust file fixed up.
Well, I'm not saying you can't, but it might be better success rate if we did, because now you don't have conflicting information. Because under the U.S. Attorney's Manual, it says basically that individual master file, all other agencies must match that. So if you're in court saying you're beneficiary and then this master file says you're trustee, they're going to go by that master file.
And you think they have that in the court, do you?
Well, now you got the burden of proof coming back on you, but you should have done the proof of the trust because you're the one claiming trust anyway. He who claims trust must prove trust. So if you got the superseding information that is newer, say, than over the master files, but maybe you just haven't put it in there yet, then your chances of success have gone up. Because
that's really take.
You know, you've got the newer information. You got the newer SOIs.
But therefore, what you're saying is that when you put this res number you put in to claim everything, in a sense, your mortgages, your leases, whatever you got in there, you would be putting in the tax file number as well.
Yeah, on the master file when we claim and terminate the straw man, yeah.
But do you have to claim it and terminate it at this stage? Can you just put in there like it's a notice and that you are the now are the.
You're going to have to claim the titles and merge the titles and then terminate the straw man.
Well, that's a big thing to do before you go to court on a matter of children.
But you could just treat the individual court case then as a trust.
Well, that's what I'm saying. So I'm basically saying I'm just going to pull the leaf off a tree here. I'm pulling out the root. I'm just going to, like a speeding fine or whatever. I'm just taking this as one little small part of it. I'm not taking the whole shooting match here.
Depends on your skills, the amount of how big of a bite you want to take.
Yeah, well, this is just a particular one with the children right now. We've got a court case, so I think we're doing that would be better than nothing. It would certainly throw a monkey wrench in there anyway, wouldn't it?
Yes, it would. Yeah.
Yeah. So, but how long before? But you're saying you want to. This is the thing you're working on at the moment, isn't it? Getting this, changing the main file.
Yes, right. That's what we're working on now.
Yeah. So you could be a year away. So
hopefully not that long.
In the meantime, people have got other things like other issues, like this particular one. I've got ones with council, and I've got ones with old leases that I want to take on. Instead of doing debtor-creditor stuff like commercial liens,
you can always do it trust-wise. You know, do it the trust way, NTT-wise.
That's what I'm saying. That's what I want to do. But they'd be on individual things that I'm doing it on.
Yes, I would recommend doing it on an NTT individual basis.
Yeah.
That's
be
debtor-creditor as far as I'm concerned.
Beg your pardon?
I believe it's better than debtor-creditor.
Yeah. That's what I'm saying. It'd be better to go the trust way, than going the debtor-creditor way. Just treat as an individual trust and just go for that individual trust that you're dealing with at the time. Yeah. Like this particular one. Yeah. Okay. Yeah. Well, I think that's the best. It's got nothing to lose, really. The debtor-creditor is a definite loss. I think at least the trust way, I think you've got a more than a 50-50 chance. And they would have to find out. They'd have to actually go to the taxation department and find that they put yourself as. I don't think they'd even go that far. Mm-hmm. I don't think they probably wouldn't be aware themselves of that.
Yeah, they may drop the case. Yeah.
Yeah. Okay. Thanks, Christian. That's great. Thanks very much.
Okay.
You can mute me out, Matthew. Thank you very much.
Yeah, you're welcome. Thank you for the questions. Guest 4 has a question for you, Christian. You've been muted out, Guest 4. Go ahead. Is that Albert? Albert, do you have a question?
Hear me?
Yeah. He just muted himself out again. Oh, there you're back.
You guys hear me now?
Now we can. Go ahead.
Okay. This is just a follow-up, Christian. This pertains to an executive agency that doesn't want to do their job. You know, in other words, just to put it in plain, simple colloquially of the day, they don't want to process the claim, and they want to dump this girl, you know, by slowly twisting the facts. Anyway, what can she do to them to ignite, in other words, put fire on their feet to do their job, since she's already started that process? Do you have any opinion on that?
A court of equity will enforce or enjoin somebody from not breaching the trust. So if they're going to breach the trust in some kind of duty that they're supposed to be doing, the Court of Equity under trust will put an injunction against them, forcing them to do what they're supposed to do. That's why I keep saying the greater power of the trust comes in and preventing somebody from breaching trust. Not after the fact, once they breach it, to get them to do the duty, but before.
Outside the scope of court, I was thinking, because this lady is just not very well versed in court.
Well, you can't get equity unless you're going into court.
Okay, I was thinking that before she does that, maybe she could put a little fire on the feet of her boss, this lady's boss, making a complaint about this the job performance of this person.
Yeah, without going in a court of equity, that leaves out trusts, and if we're going to leave out trusts, I would just assume, not go that route myself.
Okay.
Plenty of things she could probably do. She could probably find fault with maybe a form, procedure, or process that they should have granted or something, which might take some digging. And she couldn't come at that litigation-wise, then again, that's court. She doesn't want to do that. So that doesn't leave much otherwise than just making an administrative process, again, under the debtor-creditor stuff that we've done in the past, and maybe getting a lien against them for a non-response. And then, again, to enforce it, you're going to have different means of, maybe. It just depends on what she's capable of doing. I don't know. But I would prefer trust. That would take in the court of equity.
I have found that a lot of these agencies that are employed to help the public at large, with this type of stuff, a lot of them fail to actually perform their job according to their mission statement. So I was thinking that maybe before she starts going to the court and learning that stuff, to go into the private chambers, and she should put a fire on the feet of the people that.
That's what I said. Find some kind of fault in the form, process, or procedure that they were supposed to be obligated to do that you found out that they didn't, and now you got them some kind of a form or procedure or process violation.
Thank you, Kristen. That was just a thought of mine that I needed clarification, and you did good. There was another question that she had. They have classified this woman as an illegal, by document that she received. And I just thought I'd throw that in, that's how far this executive agency is planning to go.
Well, if she's not illegal, then I would rebut that and ask them to prove that she is.
Very good. Very good, Christian. Thank you very much, man.
All right, last caller here. Back to Muchu. Go ahead, you've been unmuted.
I had to unmute myself. I would just give my email out to the guy that's on Byron Bay. It's because I'm doing a birth certificate process here too, and the child doesn't have one, and it's Muchu. It's MOOCHOO @yahoo.com.
Okay.
I think he's still connected via the internet.
Yeah.
Hey, Christian, I got a question for you.
Yes.
I've shared some of your NTT concepts with some colleagues of mine, and a lot of times questions that arise to me are, is this proven or is it just a theory? Have you had any feedback from anybody in the group or any of the ambassadors that have actually implemented these strategies?
Well, everything that I've been exposing here is not theory, because I've been exposing what they've been doing for hundreds of years.
Well, agreed. I'm not disputing that. I'm just asking if there's any personal testimonies that have come back that have, now that they've been given the light has been shed on kind of what you're saying has been used for centuries.
We've got too new of a track record yet, and we've got people, that are doing things, but...
Okay. So stay tuned.
Yeah, stay tuned, yeah.
Absolutely.
Give us years like debtor creditor, give us 20 years and see what happens. In fact, I don't think we need that much.
Absolutely. No, I hear you. Personal testimonies always kind of show that where the rubber meets the road on new.
Well, if Christopher Columbus had to wait till somebody proved that America existed, he would have never left. Edison would have never discovered the light bulb unless somebody showed him that he could make a light bulb. That way of thinking that's a fallacy.
Sure. Well, I think...
Tell me that this works and then I'll try it. No, that's a fallacy. You're ever trapped in a box, you will never step out because you don't believe anything.
Edison knew that the light bulb existed. He just needed to find a way to have it manifest.
Yes, right.
Yeah, well, that's faith.
I don't know of any shaky tools. I only know shaky tool holders. That's what makes it work.
Yeah, it's
Holder.
You believe in your heart that it's true. You believe that it works.
Yeah,
it's just a matter of time.
I go by sound concepts. I go maybe by some examples and models and things, and then, hey, we step out in faith and we go ahead and we put it into action.
Yeah, faith without works is dead, so you put it into action, eventually it'll manifest.
Yeah.
Because of your faith.
Mm-hmm. Keep on seeking, keep on asking, keep on knocking.
Exactly. Well, thank you again, Christian, for another great call. It's
hey, I've got a little announcement to make before we close out. So
absolutely, go ahead.
Next Saturday on the Saturday show of Money Banking and Trust, there might not be a show. So if there is no show on the regular network that we were on for any reason, or if we get cut short, everybody can jump on to the number we've been using on the Monday and Tuesday night calls, which is the number is 712-432-0075, and the PIN number to access that is 917030#. And that number again is 712-432-0075, and the PIN number is 917030#.
And what time are those Monday and Tuesday night calls?
The Monday night call is 10 o'clock Eastern Time, 10 p.m. But the Saturday call is at 7 on a different number, and we're having some problems, and Saturday will be my last show. I'm announcing that now. Saturday will be my last show on the realpublicradio.net. And we will be switching to this number, or possibly another one, for a show that will probably be starting at 9 o'clock instead of 7 o'clock.
On Saturday night?
Yes, on Saturdays. But if we get to this last show here and there's got some problems and the show doesn't take place, because there was no show last week and I was not informed, I was cut off. And we did a talk on this number that I just gave you, and we had a few people on there. But that's the last time that will ever happen again. From then on, it will be this number or possibly another number. And so if there is no show, look for it on this number that I just gave you on Saturday at 7 o'clock.
And when is the Tuesday night call?
The Tuesday night call is at 10 p.m.
It's the same as the Monday night, okay.
Yes, uh-huh.
So Monday 10, Tuesday 10, Saturday 7, going to 9 p.m. eventually.
Right, right.
And your last call on the Real Public Radio is next Saturday at 7, and if it doesn't work on Saturday, then go to the 712-432-0075 number.
Yes, if we have any problems this coming Saturday, just go to this 917030#. So we'll probably have to be switching over. But anyway, just for announcement.
Outstanding. Well, thank you for the update. And again, thank you for taking time to teach us and mentor us. Looking forward to hearing you again next Wednesday night, same time.
Okay.
Thanks,
right.
folks, for joining us, and we'll see you next week. Thanks, Christian.
Thanks, Matt. Good night.
Good night, everybody.